I was teasing Ann when we were starting this, we were preparing for the presentation. We're not really, at least I don't consider myself to be an ethics expert, but I think we're here because we have gray hair, and we can help facilitate a discussion about ethics, and especially in the context of bankruptcy and bankruptcy representation. So that's what we're going to do.
We want this to be interactive as well. We
Yes.
don't want to just sit up here as talking heads. So we'll throw out questions and get your opinions as we go along. And please speak up so we can pick it up on the tape.
And I guess if we don't, we know most everyone, we can call on people. So,
It'll feel like law school all over again.
anyway, so please volunteer.
You don't need to stand up if you're called on.
But you do need to speak up. And we're going to tee off the presentation by just talking about the topics we're going to discuss. And just an idea, gives you an idea where we're going. We're going to start talking by limited representation. We're going to then move on to undisclosed assets. We were joking to start with some of the people as we're waiting to start. I wonder if anyone's ever had a client who has not disclosed an asset.
Never. They tell me everything.
So everyone should have some experience. We're going to talk about terminating your representation, some of the issues to consider. We're going to talk about after your representation is terminated, what is the client file, what is the client entitled to, how to think about that issue. And then we're going to talk about conflict of interests, assuming we have time. And just as a reminder, we're going to have some hypotheticals. They're going to facilitate discussions, but they're not, there's no black and white answer. And every situation is unique, as you know. It depends on the facts. So.
And the other thing I'll say is it depends on your intuition. If you have kind of a basic head on your shoulders and you have a sense of decency and fairness and you remember the oath you took in the Salem Capitol, which I remember and actually spoke with somebody about that yesterday and explained that a lawyer has kind of a dual duty to their client and to Lady Justice. And so try to remember what your oath was, because you're an officer of the court, and that means you have a higher duty that you need to always bear in mind when you're representing a client.
Right, and we know that the rules of professional conduct, this sort of balance, are different duties that we have as an attorney. Our duties to our client, that's the paramount duty to provide competent, adequate representation. Duties to the court to be accurate and complete, and then our broadest duties to the public. And so we're balancing a lot of duties that are embodied in the professional rules of conduct. So we're going to talk about teeing off your representation. And here's a hypothetical that we're going to present, and then we're going to throw it out with a question to everyone here. So you have an initial meeting with some potential clients, John and Jane Groves. And John is one of 3 members of a limited liability company called Green Groves LLC. And John is a developer. He is developing a golf course in Southern Oregon. And it's his brainchild, it's his baby. It's really important for him, but obviously he's here because he's having financial problems. He formed Green Groves in 2018 with his brother and his brother's best friend. And Jane, his wife, is not involved in the LLC. She's a school teacher and just has had no involvement. John tells you he's most concerned about a lawsuit that was filed by his brother and his brother's best friend. And in that lawsuit, his brother and his brother's best friend alleged claims for breach of contract, misrepresentation, and embezzlement. And you agree to represent John and Jane in filing a Chapter 7. You conclude that a Chapter 7 is the appropriate bankruptcy case. And the question is, can you limit your representation to exclude all adversary proceedings and all contested matters. And with throwing it out, has anyone in this room ever limited their representation to exclude adversary proceedings and contested matters?
Yep.
Probably everyone, I would imagine, if you represent a debtor. So I was kind of making that as a broad question, because I would assume you don't agree to represent your client or debtor in all aspects of a bankruptcy case. So anyone have any ideas? How would you think about whether or not you could limit representing John and Jane in a Chapter 7 by excluding all adversary proceedings and contested matters? Is that just something that's a no-brainer you could do, or are there concerns?
Mr. Parker.
The problem I think you get into is if the primary reason for the bankruptcy is a fraud, and you know that going in, there may be an issue about unbundling,
Because?
because you're not really giving the correct representation of the client.
So you think maybe there's a competence issue? That maybe if the only thing he's got going on is this fraud case, and you say, let's do a 7,
And
would,
you're not a litigator at all and don't want to do an adversary proceeding, maybe you should pass the case on.
Yeah, I never do an adversary proceeding, so therefore you need to find another attorney to represent you in litigation. And so that's probably pretty common.
so is it ever possible to exclude representation? I mean, we've done it. We know we can exclude representation of an adversary proceeding. The question is, what are the conditions you need to have present to be able to do that without getting in trouble?
Full disclosure.
Full disclosure. Okay. You think that's enough? Anybody else? There's no grade at the end. Mr. Ricks.
I think if you've got either a pending action or at least the inclination that there's going to be a non-dischargeability action, I think you gotta either agree that you're gonna sign up for the case in toto, you're gonna do the adversary proceeding along with it, or B, you can unbundle it, but I agree with Rich. I think it's problematic to do unbundling in that situation. I think you could find another lawyer who might be willing to handle the adversary proceeding representation, or you pass on the case. I mean, I think those are the 3 paths there.
So it sounds like timing is an issue. So what if the complaint was just filed and the state court lawyer that they've retained or talked to at least once says, oh, there won't be a trial date for 18 months. So there's plenty of time. You know there's probably going to be an adversary complaint filed. So does timing ever have anything to do with it? Mr. Mitchell?
Yes, of course. I mean, it depends on, all of the details and the facts of whether or not you're going to have limited representation. And so let me show you here. I would start my consideration of the issue with ORPC 1.2b. And that rule allows a lawyer to limit the scope of the representation if the representation is reasonable and if the client gives informed consent. So we've touched on a lot of those issues between what Doug has said and what Richard said and what Keith has said. But the question is whether or not it's reasonable. And in this circumstance, when we have a client it's probably a near certainty that his brother and his brother's best friend is going to file an adversary proceeding to have the debt be declared non-dischargeable. So that's a fact that would say it's not reasonable to exclude the circumstances. Now, I can throw in other facts that would make it more reasonable. Maybe John and Jane have a lot of other debt that they need to get rid of, or maybe they have, tax debt that they can get rid of, or something else that makes it a bankruptcy case makes sense whether or not they get a discharge of that particular debt. But it depends on whether or not it's reasonable. So you have to sit back, you have to look at the particular facts and decide whether or not it's reasonable under these circumstances. Then the other is, Keith was talking about full disclosure. The rules talk about it in the context of informed consent. And informed consent, that's in Rule 1.0G. And what is informed consent? Informed consent is providing adequate explanation regarding the material risks and alternatives. And so they don't have, if you look at it, in this particular case, you don't have to get informed consent confirmed in writing. But who would rather have it in writing and who would rather have it orally? So you want to get informed consent confirmed in writing. And you want to make sure that you do it in a way that you're providing a clear, simple description about the proposed scope of your limited representation. And
So you think we have to explain what an adversary proceeding is?
I think you do. I think you have to say, you're going to file this bankruptcy case, and I am not going to represent you in an any adversary proceeding. And an adversary proceeding is like the lawsuit.
Within the bankruptcy.
Yep,
That's how I describe it.
that your brother and your brother's best friend have already filed. It's just
They're
going to
just going to move.
Yeah, to bankruptcy court.
Right.
And-
Or maybe not.
or maybe not. But that's the risk, is that they're going to basically litigate that issue in bankruptcy court, and I'm proposing not to represent you in that proceeding.
So one other scenario, and that is, you're getting close to trial. There's a very high likelihood that relief from the stay will be granted to continue the state court litigation.
Yes.
And if you give full disclosure, one of the issues there is going to be this differing standard of proof. Because in the state court, it's going to be clear and convincing evidence. In the bankruptcy court, it's going to be preponderance. And I have represented clients who have recommended consent to relief from stay, get the higher standard in the state court if you're going to
Yes.
have to try the case in one place.
Right, and you may not just litigate the discharge issue, but you'll litigate the underlying facts with a higher standard. But
Do you think we could have, what if I just put that in a fee agreement and had them sign it? Isn't that good enough?
it depends on how clear the fee agreement is.
Have you read the Sear decision?
Yep, the Sear case. So
Whew.
that's a really
Scary case.
scary case. It's a good case. 515 BR 599. We've talked about it in other presentations. But that's a case that comes from Nevada, went up to the Ninth Circuit BAP. And in that case, a bankruptcy attorney who just does bankruptcy representation, meets with some clients, and the client, the facts are really colorful facts.
But he didn't tell him that.
Yeah, he didn't tell
He
them.
didn't tell it.
Yeah. So anyway, what happens is that he meets with the client, gives them a writ of garnishment, and the client didn't tell him until after the fact, but he sued his former employee for sexual harassment. And sexual harassment was based on emails from some women employees.
That the plaintiff doctored.
Yep, that the plaintiff embellished.
Embellished. He embellished them.
They embellished them. And so you can imagine that the trial court didn't really like the embellishment and ended up sanctioning the debtor for $70,000 and having him responsible to pay attorney fees.
And this is all before he gets to you as the potential bankruptcy lawyer.
And they meet, has one meeting with the attorney, mostly meets with the paralegal, 19-page fee agreement with a bullet point listing of paragraphs
We don't represent you in adversary proceedings.
with initials where you initial all the way down the line.
Handed them the debtor handed the writ of garnishment to the debtor's lawyer, and it was from St. Rose's Hospital
Yes.
for $64,000. And the lawyer made the assumption it was a medical debt. Didn't read the underlying complaint. Didn't know there would be a fraud lawsuit.
Fraud lawsuit, non-dischargeable lawsuits filed. Says you're on your own based on our agreement. And pretrial conference occurs. The bankruptcy judge isn't very happy and issues a show cause order on the spot
To the lawyer.
to the lawyer.
Where are you?
You should not
Why
have
aren't you here?
limited your representation of the debtor in these circumstances.
So I'm reading the opinion and I'm going, whoa. I mean, this guy was really thorough. I mean, he had a great fee agreement, but there was a dispute of fact about whether or not his paralegal, he said, normally what we do is a paralegal goes through and reads it to him and explains it to him. But I don't have any independent verification or recollection whether that happened in this case. So you think there's a problem with that? Let's assume that the paralegal did that. Would that be enough? Megan, you're saying no. Why?
They might not be able to answer the questions that the.
So you think it should be the lawyer? What's the rule say? Should be the lawyer, right?
For
Adequate disclosure and
yes, the
getting
lawyer.
informed consent.
So yeah, we were asking about that before, and we have it up here. 1.0G says the lawyer has communicated adequate information and explanation about the material risks and reasonable available alternatives. And by the way, Doug gave a pretty good laundry list of the alternatives. Not represent, find another attorney who's going to represent you in all aspects, or
Or don't file.
or you do or don't file, or you do all the work yourself. And the risks are that it's not going to turn out well. But so that's informed consent.
What I got from the opinion was that I think there was a history with this guy. I think he was probably a lawyer that was pretty form-driven, but didn't really have a lot of people talking to his clients. And I got the sense from reading the opinion that the judge was a little bit sideways with this guy to start with. So just be aware that you need to be careful and really examine your protocols and follow them to the letter. And make sure the lawyer is the one talking about legal issues and not your paralegal.
I think the other thing too is that in this case, the lawyer probably didn't get informed consent because he didn't speak about the risks and the alternatives.
Well, he didn't know them because he didn't look at the complaint, and the lawyer wasn't terribly forthcoming about what was really going on.
It is.
But we have this new duty since the 2005 amendments. We have to investigate our own clients. The U.S. trustees made that pretty clear. You have a certain duty to look at bank statements. You have to look at, you've got to do analyses. You have to almost be confrontive of your client in certain circumstances. And, and it's tough when you can't, if someone's going to lie about something, sometimes you can't prove a negative. So be careful.
Yeah, and the way I look at it is engagement letters. I think that it's easy not to give them as much attention as we want to, as they deserve. And the reason why is because we're not getting paid for them, and it's more like a form. But an engagement letter is the way that you are going to push the boat off the dock. And it's going to be either smooth waters or bumpy waters. So you want to make sure that you take the time to say what you're going to do in a bankruptcy case and what you're not going to do. And if you're limiting your representation, then you want to be able to say what are the alternatives and what are the risks of the proposed limited representation.
So then we need to tell him the rest of this story on this deal.
Yeah.
So this lawyer, while he's not representing the guy in the adversary proceeding, gets an offer of settlement. So it's a $67,000 judgment. They've already taken it. They're coming in an adversary proceeding, and they make an offer through the lawyer to settle for $23,000. And the lawyer just kind of passes it on to his client and doesn't do anything more with it. So.
Yeah, the case goes through and looks at a lot of ethical rules, competency, communication, things like that. But it all flows through 1.2b, because if you follow through with 1.21b, then you're going to provide, you're going to make a determination about whether or not it's reasonable, and you're going to provide adequate information about the potential risks and alternatives. So don't forget about LBR 9010. It lists the minimum services that you have for Chapter 7 bankruptcy case. I think I have it up. There they are. Here, everyone should pull them up regularly and just sort of look at them. And you want to make sure that you get informed consent, confirmed, in writing because you don't want to have a problem of proof, problem of evidence. And you want to make sure that you use simple, concise, clear language that someone who's not sophisticated can understand. All right. Anyone want to add anything? Any questions? I think that's a good place to start. We're going to move on, and so you teed off, and guess where you ended up?
In the bunker.
That's right. So I came up with the golf analogy, Ann didn't. So.
For those of you that don't know, I'm an avid golfer, so that's why. Oh, let's do this.
Yeah, I sent her the PowerPoint, and it's like, wow, let's do it. So, has anyone ever had a client who hasn't been 100% forthcoming? So I expect some participation here. So here's our next hypothetical. We're still with John and Jane, and you filed the Chapter 7 bankruptcy case for John and Jane, and 1 week after you filed the petition and the schedules and all the other bankruptcy documents, you find out that John received $75,000 inheritance from his uncle, and that he had deposited money in his dad's bank account.
Before bankruptcy.
Before bankruptcy, yep. And when you asked John, why didn't he list that, that bank account and that money on the questionnaire and in the schedules, he says, well, I didn't think I had to do that because the bank account was not in my name. And so you advise John and Jane that you need to disclose the bank account, and we need to file amended Schedule A and B and Statement of Financial Affairs. And John says,
I don't want to.
I don't want to. You imagine that?
What do you do?
What do you do? What would you do? Go ahead. Anyone have any ideas?
Wouldn't you have to withdraw?
You have to withdraw.
But isn't that a requirement that's allowed withdrawal, that you're effectively disavowing the statements?
So you allowed withdrawal, noisy withdrawal.
Noise withdrawal.
A noisy withdrawal, and you basically say, you tell the court,
I can't tell, but I gotta go.
I can't, the schedules may not be accurate.
Oh, you don't even say that.
Yep. Well, yeah, I know it. That's what he's saying. Doug, go ahead.
Before you get to the withdrawal question, though, I think you probably need to have the come to Jesus meeting with your client to tell them,
Of course.
look, this is a big problem. You've made these disclosures under penalty of perjury. We know it's wrong. You are going to suffer severe sanctions as a result of leaving this stand. There's no, I'm going to get out of this scenario for you. And if the person then, after hearing the parade of horribles that will be visited upon them for just wanting to stick with a knowing falsity in their schedules, then run through the withdrawal scenario. But I think if we get to that point and the client says, yeah, I'm not going to do it, I'll take my risk, it's worked for other people get off, then okay, then I think mandatory withdrawal situation at that point.
So the first thing is that you have a come to Jesus meeting, you have a real serious talk with your client, and you share the extent of the ramifications of not amending schedules and bankruptcy documents.
And sometimes it's very helpful to call in a criminal law lawyer to sit in on that conference with you, because it scares the hell out of people. And they get real about the severity of what they've done, and oftentimes the wife will start crying and the husband will say, all right, honey, we'll tell. But bringing in a third party that's a criminal law lawyer that will scare them is sometimes enough to get people to really get it, that this is serious and it's not something they can do in a cavalier way and get away with it.
One thing to keep in mind, and so we're talking about the possibility of a noisy withdrawal, but ORPC 1.6, that's confidential information. And we know that confidential information is basically any information relating to your representation of your client, so it's broad. There are exceptions, and one of the exceptions is to prevent a crime. But in this case, there's probably not a crime because John just just didn't understand, and doesn't have the intent. So there's a real question of whether or not you can disclose confidential. Judge Hercher.
You, I think your hypo said this is shortly after the petition date.
Yes.
That implies that it's before the 341.
It
Yes.
is.
So you're looking at sitting next to the first of the 341. So if the question is the crime a future crime, that would be a factor.
Yes. Yes, it could be a factor. So, but what happens if, and this is where our next, we were going to add a wrinkle to the hypo, which fits in perfectly.
It's always wrinkles.
Which fits in perfectly with Judge Hercher's question. What if John says, I got this creditors meeting, and what would happen if I just don't show up? What do you tell
Can you tell him?
him? Can you tell him? What do you tell
Can
him?
you tell him?
What is your duty?
What would happen?
Has anyone had a client say, don't show up? Go ahead.
I've had a client.
What do you think?
Well, you could tell them the case could be dismissed, but you could also tell them it's not going to necessarily solve their problem.
So in other words, they would still face, you could tell them the case could be dismissed, but you could also say the trustee may continue the creditors meeting. And if the trustee continues the creditors meeting, you can remember all the other bad things that we talked about? Denial of discharge.
So,
Yep.
wasn't his brother suing him?
Yes.
I mean, wouldn't his brother know if their uncle died and that maybe he got part of the inheritance too?
You think the brother would call the trustee?
I think he might. He's already mad at him. If the brother had been smart, he would have said, we'll settle this adversary proceeding that, go file bankruptcy, we'll settle it, you give me the inheritance, wait 91 days or maybe a year and then you can file.
Again, I think you have to be, and I think it also relates to what Doug was talking about too. You have to have another come to Jesus conversation with your client and say, so not only can you say, this is what can happen to you in the bankruptcy case, it's going to go from bad to even worse if you don't show up. But, by the way, here is my duty. So what is your duty? He doesn't show up at the creditors meeting. John and Jane don't show up. And you're there. What do you do? What can you do? And so we talked about there's a possibility of a future crime. To prevent a crime, that's a future crime if they don't show up. As an attorney, in 8.4A3 and 8.4A4, I think I have them over here, you prohibits attorney from engaging in conduct involving dishonesty, fraud, or deceit, or misrepresentation. Don't forget about that. 8.4A4 prohibits an attorney from engaging in conduct that is prejudicial to the administration of justice. And I didn't have it down here, but there's also 1.2, which talks about a lawyer shall not counsel a client to engage in or assist a client in conduct that the lawyer knows is illegal or fraudulent, but a lawyer may discuss the consequences of any proposed course of conduct. So you can have the come to Jesus talk, but you're not allowed to perpetuate the fraud, perpetuate the misconduct.
But
So what would you do? You're at the creditors meeting. What would you do?
Client doesn't show up. Ms. Chapman, where's your client? I'm not sure, Your Honor. Or Mr. Trustee, I'm not sure. I'll reach out to them.
Do you ask the trustee to continue the creditors meeting?
I wouldn't.
I wouldn't.
Is that helping the client potentially evade? I mean, I don't know.
I think you can't argue that it does help, but because
Dick?
Along those same lines, say you have a hearing in front of Vanessa, she asks a question, your client clearly lies.
yes.
What's your next response?
Well, I mean, so the question is, if anyone didn't hear it, you're at the creditors meeting and your client does not tell the truth, it's a clear perjury, then, you have the same sort of standard. It triggers 3.3, I think. And let's go ahead and look at the rule. Let me pull it up. Because it's important, there's 3.3b and 3.3c. 3.3b says a lawyer who represents a client in an adjudicated proceeding, probably would include a creditor's meeting, and who knows a person intends to engage in or is engaging in criminal or fraudulent conduct related to the proceeding shall take reasonable remedial measures, including disclosure to the court if permitted. Then C says the duty stated in paragraphs A and B continue to the conclusion of the proceeding, but in no event require disclosure of information otherwise protected by 1.6. That's your duty to keep material confidential. So you probably have the confidential duty probably trumps the duty to disclose. But what I would do, with all that running through my mind in the 15 seconds that you have, or maybe less, is ask the trustee to, like, can you stop this creditors meeting? I need to go out in the hallway, and I need to talk with my client, and can you put us back at the end of the meeting? And then you have, like Doug said, a come to Jesus talk again about your client, and hopefully you're able to persuade your client to correct the misstatement. And sort of maybe you can have some explanation that you put on the record that serves your client and protects your client's discharge in those circumstances. And so that's what you would do.
Sometimes what might be technically a lie is you can tell by the context sometimes the client is just doesn't understand the question or is confused. And so sometimes, you know, I can kind of help them. I do kind of help them. And the trustees in this room have seen me do it. It's like, oh, and I'll jump in and I'll say da-da-da. And, you know, I'm only doing it in a situation where I know the client knows what the truth is and is just confused and we just want to keep moving and not turn into this dramatic thing it would be if, you know, like this happened, where the guy's clearly, let's say the guy says, okay, we're going to amend. Well, you sure would want to amend before the hearing. But let's say you found out at 7:30 in the morning, the wife calls you, the hearing's at 9 o'clock. The wife calls you and says, I've got to tell you there's $75,000 sitting in my, you know, in another account. And we didn't tell you. But I've talked to my husband, I'll put him on the line, and we're going to tell the truth at the hearing. And then you get to the hearing, you haven't had a chance to amend schedules. Now you get a chance at the beginning of the hearing to say, are there any changes? And then the clients remain silent. In that context, I would say, well, I had a conversation with my clients earlier today. Let's continue the hearing for a moment. And then I'd take them and say, what the heck are you doing? You said you'd tell. No, we got to tell. I didn't have a chance to amend the schedules. You got to tell. And then if they don't tell, then what do? They go in there and they just remain mum. Do I have to get up in the middle of the hearing and say I have to file a motion with the court immediately? Because you know, you're watching them do it.
Well, you have to, you know, you're representing an attorney, you're representing your client in an adjudicated proceeding, and so you need court permission to withdraw, right, under 1.16. So you can file a motion to withdraw. That's going to be your next step, but you have to go back to the office and file it. And the question is, what do you say in your motion to withdraw? Rich?
Johnston, the side to that issue is you have to remember that it's not adequate just to tell the trustee about a change at the hearing. You actually have to make the change on the papers.
Yes.
Right, you do.
Yes, you do. Some trustees will tell you that too. So that's a good reminder. Any idea, what would you say in your motion to withdraw in that circumstance?
Is it permitted to disclose to the tribunal what's really going on?
It's still confidential information. I don't think you can disclose it.
Yep, and so Keith says it's you still have a duty to keep information confidential, and you should not fully disclose what your client has told you and what you know.
What if the person whose money the bank account is sitting in calls you and tells you, I think I have money that belongs to your client and I understand he filed bankruptcy. I don't want to be involved. I didn't understand why he gave me some story about his bank account. So the money's in my account, but I understand he filed bankruptcy and I don't want anything to do with this. So now you're not finding out from your client, you're finding out from somebody else. Can you tell now?
It's not confidential.
It's probably still confidential.
You think so?
Yeah, it still relates to your representation of your client. That's what I would say. And so, I mean, look at 1.6b. It says a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary to disclose the intention of a lawyer's client to commit a crime and the information necessary to prevent a crime. So you probably have the authority to disclose the information, but you're not required to.
Maybe you want to err on the side of disclosure to protect yourself. Because when people lie, guess what they often do? Blame other people. You were in on it. You told me to do that.
Judge Hercher.
You mentioned 3.3b earlier. I'm interested in knowing more about what it means in the context of criminal or fraudulent past conduct, how you fulfill your duty, your affirmative duty to take reasonable remedial measures. That's the language out of 3.3b.
Right. And so, yes, and then you have 3.3c that balances the duty to keep confidential information. And so let me explain it this way. So there's or my view about it this way. There's a formal opinion. Let me get it. Let me give it to you. No, that's not it. Anyway, I have the number here in my notes someplace. But there's a formal opinion. It's in the criminal context, but it's still very helpful. There's two brothers, brother A and B. They're twins. Brother B is driving down the road, or it's brother A driving down the road, and he gets pulled over. His license is suspended. So he's not very happy. And so he tells the police officer that I'm brother B. And they get ready to go to hire the attorney. Attorney agrees to represent brother B.
Brother B?
He's representing brother B.
Okay.
Because
he thinks it's brother B, but it's really brother A.
it's really brother A.
Okay.
And brother B says,
The hell?
tells him as he's going, discloses what happened and says, but I don't want you to say what happened. I just want you to say that I wasn't served. I wasn't properly served. And I don't want you to challenge the substance. I just want you to say properly served. So the bar opinion says you have a duty to keep confidential information. You're not required to disclose the information, but you are required to withdraw. But you may, but you're not required to. So that's kind of similar. There's a crime that's going in the future, so you may disclose, but you're not required to, but you have to withdraw. So the lawyer couldn't represent brother B and perpetuate the fraud in that circumstance.
I wonder how many times they've done that before.
I wish I was a twin.
You never do anything bad. What are you talking about?
So we get a lot of motions to withdraw, and I ask, are you withdrawing because you have to, or is this permissive? And they say, I have to. And I say, I'm assuming you can't tell me why.
Yes.
And they say that's correct.
So
So can I order them to disclose the reason that they're withdrawing? Or can I say something to the effect of, if you believe there's a crime that's been committed or may be committed, I'm going to authorize you to disclose it? Because I'm sure lawyers are concerned that they're,
yes.
just like, Ann, you raised the concern that
You're going to get accused.
they could also say you shouldn't have disclosed that.
Right.
So
If you order them to disclose, I think you can, as a judge. I think you can order them to disclose. I mean, what I would do in a circumstance, and had circumstances when I've had to withdraw, and I would say it's because of professional considerations or because of irreconcilable differences, And I think there's an ABA formal opinion to that extent that gives that guidance. But I've been in state court proceedings where the state court judge has said, I want you to come back into Chambers, attorney who's filed the motion to withdraw, and have a conversation with me. And then it was a limited discussion the way it was presented, but and so it just confirmed that it was because of an ethical obligation.
Another come to Jesus talk.
Yep, and so
You got to get good at them. If you're going to be a lawyer, you got to get good at these kind of
if
talks.
you represent,
Justin?
clients with check it
What
back.
about the idea that it's a continuing crime, that you should report?
So 1.6 gives you authority to do it, but I don't think you're required to do it. And I think that 3.3 says that that you still have there's still balancing regarding your duty to keep information confidential. And from the sort of a policy perspective, we want clients to be forthcoming to attorneys. So we want to make sure that what they tell attorneys are confidential, because otherwise they'll never tell us. And so there is serious policy reasons why you'd want to make sure that you keep things confidential. But on the other hand, obviously, you have people who hide assets that are worth a lot. And we've seen that. I'm sure everyone has seen that to some extent.
So Johnston, if your motion to withdraw, if you're allowed to say in your motion to withdraw that, I'm required to, disavow the validity of the schedules, if that's the phrase, right? I'm not disclosing the confidential information, but I'm giving a shout out to Judge McKittrick.
Yes.
I'm disavowing the schedules, right?
You
Now
could-
I imagine that I'm not going to get the question from Judge McKittrick about explain why you can't. Why are you withdrawing?
Yes.
And that also is going to notify the trustee.
Well, but you know what? That's why we use the term noisy withdrawal, because everybody knows. I can't tell you why, but we all know the debtor did something they're not supposed to,
Yeah.
and I can't participate in it. And so, we can say disavow the validity of the schedules, which points people in the right direction, but they were probably going there anyway. So, but that may keep you personally out of hot water.
At least answering the question. But if you have a noisy withdrawal, and there can be a question of whether or not you should have had a noisy withdrawal, right? Whether or not there was, because it's not, a lawyer may reveal information to the extent the lawyer reasonably believes there's room there to make arguments that the client intended to commit a crime or you were preventing a crime. There's room there to have arguments. And if you have a litigious client, you may be facing a claim, you may be facing a bar complaint, you breached the duty to keep information confidential that you breached. So it's a difficult situation, and so.
So now I've gotten the ball out of the bunker.
Yep.
Kind of maneuvered that whole thing. What do I do? Do I withdraw or not? What do I do? And now I landed in a divot. So for those of you that don't play golf, a divot is when your ball in a divot, it changes the whole shot. So now more twists. Keep going.
Well, this kind of gets back to where we're talking about, and so John is upset, and this is basically the discussion we're talking about. So we'll breeze through it. Is upset that you don't have an alternative to disclosing the existence of the inheritance and the money, and he said that he's not going to reveal the account or the money, either by filing an amended Schedule B or by attending the creditors meeting. And what's more, he writes in an email, "You're fired. Don't show up."
Thank you.
So what do you do? What's your duty?
What do you say in your motion to withdraw?
What do you say? We've talked a little bit about it.
What do you say in your motion to withdraw?
I've been terminated.
Period.
You have a duty to keep information confidential. you're still in the same place, right? There's the exceptions in 1.6. So if you make the determination that you think it's reasonable that you're going to prevent a crime, then you can disclose the information. Or to comply with the court order, Judge McKittrick. It says here at the bottom, that's one of the exceptions. So if you get a court order. But that's sort of what you're doing. You're in that case, you're still in the same predicament because you still have the duty to the court under 3.3, where you're obligated to make a reasonable remedial measures. So you should be circling back again and giving another run at your client to make full disclosure and explaining things. And but you don't have to disclose it, but you can. Probably the. What about, can you tell the new attorney? What if he says, and I have a new attorney, and they're going to file a substitution of counsel? Can you pick up the phone and send an email? It's like, call me, and then have a discussion with the new attorney. What can you do? What do you think? Nope. Same duty, right? 1.6, you still have to maintain confidential information.
So now you go to the 341 hearing because you've got another matter scheduled at the same time, and you sit through the hearing while you watch the new lawyer who's completely clueless, and you watch the guy lie through the whole hearing. What?
Also watch an educated trustee.
Well, I mean, nobody knows about this account with this money in it.
It's his dad's money, right?
It's his dad's money.
So
what
difficult.
can you do? Anything? I've had it happen. I've had to sit there and watch it. And there are lawyers, or there are clients that shop. They go to one lawyer, they get some information, and they kind of figure out what the rules are, and then they go to another lawyer and they get a little more information, and then they get to the third lawyer and they figured out how to play it and then get away with it. I'm convinced there are people like that. And all the older gray-haired members of the audience are nodding.
I'm nodding. I've had it happen.
Yep.
So
All right.
there was an interesting formal bar opinion that for this particular audience and this circumstance is interesting. It's related to this issue. So, and again, it's in a criminal context, and the attorney agrees to represent an indigent client. And so that means the way that I understand the criminal process is that the client had to fill some sort of application with the court making a representation about their lack of financial resources. And lo and behold, the attorney starts representing the client and discovers, wait a second, you're not indigent. What do you do? And so we're here, pro bono clinic. What would you do? So you have a pro bono client, you come in, and you start taking, and as a bankruptcy attorney, we're going to get all the information. We're telling them you have to be forthcoming, you have to be honest, and you realize, wait a second, how did you qualify to be a pro bono?
Have any of you had that happen with the pro bono clinic?
I did.
Yep.
And what'd you do? What'd you do, Mike?
What did you do?
Legal aid and said, I don't think this client qualifies for your services. It was incredible. I don't know what happened in the intake process. It doesn't happen often.
So you declined to go on. You turned it back.
Yeah, I did it, and they took the client back.
You know what I was told? This happened deep in the representation, where we had a bond and blah, blah. And I told the client, I said, I don't think you qualify for the pro bono clinic. I'm going to have to call them and tell them. So I called and I said, I'm pretty deep in the representation. They probably don't qualify. They don't really have the money to hire me anyway. And she said, well, do you want to be a sucker or not? I'll never forget that. I'll never forget that. You want to be a sucker? Because, I'm sure you guys at Legal Aid have seen a lot of people scamming the system, and you get tired of it.
Were you a
And
sucker?
I think I was. I mean, I was deep in it. It's like, let me just finish it up. And there was no issue with disclosure of the court. It was just,
It's a little bit different,
Yeah.
a little bit different situation because, in the criminal context, there's been an application, you're involved in a judicial proceeding, right? And when you're in the pro bono clinic, you haven't filed anything yet by the time you discover it. But, so that's an important issue. But
Well, for me, this plan did not even qualify for Chapter 7,
Oh,
so that was kind of an easy.
oh yeah, that's.
Yeah, I mean, mine happened, and it was, Vivian Cockrell was,
Dating
requesting
yourself,
the
Mike.
2004 examination for all the properties, right? So I was deep into it at that time. The other one I can remember, I was very early in the process, and I did exactly what Vanessa did. I just said, look, I don't know if you disclosed this to the clinic or not, but you might need to. And then if they say you're cool and send you back, great, because otherwise you're taking a spot that someone else might need. Right?
Yeah.
Right. So.
okay.
And I guess the way I thought of it too is that what if the client had filed, application for a fee waiver, because of their.
Ken Eiler would get to the bottom of that.
So, but that would change it because then you are in an adjudicated proceeding, and 3.3 B, the trigger is you're in an adjudicated proceeding, and so that's a distinction.
All right, let's make it really interesting.
I have a quick question.
Sure.
It's a little off the wall, but we're talking about withdrawing as the solution to a lot of these problems. What if the case is closed as a no asset, Chapter 7 is closed as a no asset case, and 2 months later, you send a disengagement letter, we're done, and you get a call from somebody who says, hey, that debtor that you represented, their mom just died, and they're gonna receive $1 million, and you call the client, and they say yes, but
I'm not telling.
I'm not telling, and you can't tell.
I think that's right.
Right, and so it's the same. We're balancing the same duties, right? And so you have 3.3 B, and C, candor to the court, and 1.6 confidentiality. Again, it probably was a crime.
Or there will be.
Yeah, there will be a crime.
But there's no event, there's no, you're not gonna file a motion to withdraw.
You can't file a motion to withdraw. It's like someone substituting in.
Right.
And so, this case is closed, you sent your disengagement letter.
Send them a stern letter and that's it.
Yeah, and, I guess you have to go back and look at 3.3 and see what the. So who knows that the person intends to engage in, is engaging in, or has engaged in a criminal or fraudulent conduct relating to the proceeding. So you have a basis to disclose, but then you're balancing your duty to keep information
Ken Eiler's
confidential.
changed his question over the years, and his question now is something about, one of you guys remember the exact verbatim? He says it the same way every time, and he says it in this really low kind of, in a way that's going to draw you in. And he says, if you receive an inheritance, you must let me know. And he does it just like that.
You must let your lawyer know some circumstances.
And to me, to pay your creditors. Right. So, very good. That was a great impersonation of Ken Eiler. So my question is, if the debtor is on notice with that question, that they have to let their lawyer know or the trustee's office know, does that change anything? So you filed some formal paperwork, but should we have Mr. Eiler change his question to say, Ms. Chapman, if you become aware, I want you to let me know. Would that change anything?
Can't change your duty.
It seems like it gets harder because there's not an active proceeding. For some reason, that's what, is coming to me, is that, okay, I've got this duty to maintain this confidential information. Does that overcome the fact that I'm now have a closed case? Now I've got to do something. I mean, it seems easier to me that if we're in the middle of the case, that you have to disclose it.
I think same duties.
Yep, all right, so,
We're coming to the end. Well, we're going to buzz through this last little bit, and this is we're talking about paperwork, client file, and so John and Jane, they fired you, and then they request their client file, and you're like, okay, we're going to give you your client file, and in reviewing the file prior to turning it over to your former clients, you find that there's a draft Schedule A and B that lists the account number for Dad's bank account.
where the money is.
Where the money is, the inheritance, $75,000. And you also find an email there that derogatorily describes the client and asks your paralegal to prepare the schedules and other bankruptcy documents. And the other thing you find is a handwritten note from a telephone conversation you had with the bar counsel when you called the OSB ethics hotline. And the question is like, well, what of these 3 documents do you have to turn over? What is the client's file? What do you think?
First one for sure.
First one for sure, Keith says. I think that's true. So there's a formal opinion, OSB formal opinion number 2017-192. It just talks about what is a client file. It's an entire file. Anything that relates to the substance of attorney-client relationship.
Does that include text messages sent at 11:30 at night when he's had a few drinks and he
Yes.
asks me a little
Or if you happen to record the voice same thing. And so the first one, with the draft schedule, that's part of the client file. The email.
Well, it might implicate me for malpractice.
It might, but you still have to, it's still part of it. And so you still turn it over and produce it. As part of my war story that I shared with Ian, I once had to turn over attorney-client file. I've had to do it more than once, to be honest with you. But, and I found in the client file a memo from the attorney to the file analyzing a malpractice claim
Against them.
against the attorney, saying here are the elements for malpractice, and here's how they apply to the facts in this case. And in that case, I said, wow, what is that part of the attorney-client file? And I thought, if I withhold it, then I have to disclose that I'm withholding this. And so I just thought, I'm going to disclose it. It's probably in the client file, relates to the substance of the attorney-client relationship, and I disclosed it and gave it to the other attorney. And a malpractice claim was never filed.
And it's been more than 2 years, right?
It's been more than 10 years.
More than 10 years.
More
That's
than
even
10
better.
years. So statute of repose. Yep, we're done. But anyway, so sometimes it's sometimes cleaner just to disclose. With regard to the email, I would want to look at the substance of the email. If it's talking and relating to the client representation, then
This guy's really tough to deal with. I'm just going to give you a heads up. Be careful, ask follow-up questions, but I think you can do it. Go
Yep.
for it.
And in that circumstance, I probably would disclose it. There's some of the categories of stuff that you don't have to disclose are, sometimes you take a memo from another case and you put it in that file. That you can't disclose. That's not part of the client file. Documents that don't really bear on your attorney-client relationship, that bear on your attorney responsibilities, like the notes from the OSB hotline, that you don't have to disclose. Communications regarding work assignment. So a clean email to the paralegal that says, the documents in the file, start preparing the schedules, that you probably don't have to disclose. Or, sort of administrative business issues. And metadata that is expensive or difficult to extract and produce, you probably don't have to disclose. One last thing, when we're going to the end, here's one question that comes up that's often, what about the best case file, the electronic best case file? Do you have to disclose that and give that to your client? And so the
We've
answer
got
kind of is,
proprietary issues
yeah, sometimes if you have an attorney to the side who has access to that file, that software, yes, you do. But if you don't, then you can't give them the proprietary software. So, anyway, that's a quick answer.
All right, well, thank you guys so much. That was really amazing.
He did all the work.
No.
So, obviously, the reception follows. We hope you will join us. We have a number of notebooks back there that are empty, and we're giving them away for free, and we have many more. So whether you have room today or you want to have somebody come back from your office and pick up notebooks, please let Eileen from the court know. We have a bunch that otherwise are going to end up getting donated somewhere. So if you need notebooks, if you still do paper, feel free to take them. Thank you again, you guys.
Thank you.
Thank you.
I have a criticism, we never saw the ball go into the hole.